the same argument every time you start the class.
You ain't gotta get all loud.
Why?
I can't see nothing out here. I gotta go. I'm like winging it.
Yes, you're in.
I'm used to seeing. I can't see anything. It's lawnmowers. I'm just setting up, getting ready for class. The last installation of the Dred Scott case. So I'm trying to get everything ready. So I am focused. Because Fatima, yet again,
Don't start. Don't start.
is not here. Where I need her to be. You gonna do what?
Do it.
I'm trying to get a table. I need a table. For my stuff. It's lawnmowers. I would have music playing. I definitely would. I can't see myself. And I need a table, so you got to give me a minute.
Listen, this is your show. I'm just a squirrel trying to get a nut. I don't give a fuck.
What are we learning about today?
Everybody said get in front of the camera. What are you doing? You in the wrong speed.
I want to be. I want the baby to teach me. The baby's coming with me then.
Yeah, you gotta get out. You gotta go over there out the camera. Cause I don't think your mom gonna want you playing with a camera.
Where's my mom at? Is my mom?
I'm getting ready for class. You asking me questions. In there, writing documents.
Why did you do 4?
We should go talking. Fatima, am I in front of the camera or what? You're not helping. Oh, I think I'm seeing myself.
You in front of the camera, chick.
I just can't see.
Okay, well, turn it around.
It's not, I can't turn it around because then the camera thing is not going to work.
Well, get your...
Get my what? What, Fatima? What you trying to say? Yep. Always been playing.
I like messing with her. She's so easy.
Okay, what? Easy. Just call me easy. My head is so discombobulated.
Go ahead.
Completely and utterly. It's lawnmowers. I'm used to seeing myself. Which helps me to know where I'm at or know where I'm going more. Alright, here we go. I think I'm cool. Can y'all hear me good? It's clear and y'all can hear me, right? It's clear and y'all can hear me. Wave and let me know what's going on. Because I got my phone and this has a delay on it. This has a serious delay, just so y'all know. And I'm just going to go with it because I appear to be in a good position as in terms of the camera. Watching Islam. Alright, because this got a 20-second delay. Islam Moors, this is part 3. I.e. part 3. The conclusion to the Dred Scott case. Because we have to get on way more important and pressing things as it relates to our nationality, as it relates to our nation. So the first couple of classes, we went over preliminaries, over introductions. I do need to put some public announcements out there as it relates to phone calls. As it relates to, I'm just gonna go as it comes. It comes. I'm gonna try to keep it to at the end of this class so I can get through Dred Scott today and get through the 9 fundamental, essential facts of the case that all Moors, whether or not you're nationalized or not, shall be aware of, as well as I have some lawful documents as it relates to treaties and the Supreme Court. Islam, I would have definitely used that table. I didn't even think of that black table, Fatima. It wasn't even a thought. Islam wars. All right, so we're going to start with the last class. We read the cause of action that was filed by Dred Scott as it relates to getting emancipated from his presumed master, John F.A. Sandford. Now, there was some preliminary information as it relates to his prior master, who was Emerson. So he originally put a suit in between Emerson, who was his prior master, or he was enslaved to, but since his filing of that case, he was subsequently sold as property to John F.A. Sandford, which is why John F.A. Sandford, he initially abandoned the first case in favor of the second case. Islam. And all of this information is for the public record. You can pull it all up. Moors, we have to learn how to validate and substantiate information when it comes to us, Moors. We have to learn how to do that. And that is, are you going to be watching over there? That you can't see with that because it's so dark. It's out here. It's in, you can? Okay. All right. I don't want to read the cause of action again, but I just want to give fundamentals. Islam, what? Huh? Oh. I don't know why I felt the need to go all the way over there to say that, but okay. All right. Go all over the counties and all over the boroughs under the so-called sovereign states. Asiatics were getting emancipated from slavery because of the supreme laws of those so-called sovereign states. All the states of the Union were not in favor of slavery. So you had specific statutorial regulations within each individual so-called sovereign state, right? Every state was sovereign to each other. And if there was a issue of law, right? So if you went to certain states, I can't recall which particular states they were, that were where slavery was prohibited. It was prohibited in the territories. Now, when they're referring in the Dred Scott case, as well as in the Constitution for the United States of America, they're referring to those territories that were under the jurisdiction of the United States, which is different from those when they're referring in. She does it to me every time. So, you need to know the fundamental difference between state law, which is only applicable to citizens of the state, and then you have territories, which were under the direct supervision and dominion of the United States. So that was primarily the difference. You had states that were for slavery, you had states that were against slavery, and then you had the federal territories where slavery was prohibited. Islam, I'm making these distinctions because you need to know these distinctions, right? And the Dred Scott case was ultimately dismissed because of a want of jurisdiction. And you have to understand why they did. Most cases don't go farther than that. Most cases, per the law, will not go farther than to dismiss. They're not really supposed to talk beyond that because they don't have jurisdiction to even entertain or to make an argument. You can only make an argument for or against something if you have jurisdiction to even talk about it, right? I was like, so a lot of the Dred Scott case was opinions of fact that can be substantiated in the record through looking at the laws and the statutes which talked about what it is that they were arguing for or against. And you have to be able to discern between something that is meant for you and something that is outside of you, Morris. And I'm going to express one, why Dred Scott wasn't emancipated. Even though prior to him making his cause of action suit within the court system of the so-called states that were for and against it, was for the simple fact that he had a privilege as a quasi-citizen of those states. So they could decide whether or not they wanted to adjudicate or not, because he was a quasi-citizen, which is the issue with Asiatics trying to be a citizen of something that they lawfully cannot be a part of. And it's not because it's ultimately because you didn't do what you were supposed to do to even be aligned, right? I was like, and we're going to go through a lot of those things. So I don't want to belabor the point, and I don't want to go too far into talking about the particulars of the case. Dred Scott applied for emancipation because he was carried into a free state. Because he was carried in his so-called master had a domicile, or not necessarily a domicile, and a resident within the free state, that put him as well as his master under the laws of the state that they currently were domiciling in, where slavery was prohibited. Islam. So if a slave master wants to take a slave from a slave state to a free state, that free state has the prerogative and the jurisdiction to emancipate that slave. Period, point blank. And prior to Dred Scott putting his claim in for emancipation, there's at least 15 to 25. There's no consistency on how long this was, where slaves were being emancipated, becoming free through the fact that they were being carried to a free state where slavery was not a part of the municipal codes of that state. Therefore, when you put a cause of action suit in, they can't sit here and hold up something that is not a part of their judicial or statutory municipal law. Islam? Oh, if you want to stay with me as it relates to what I'm talking about, I downloaded or uploaded the document that I'm referencing, that I established based on my reading and my interpretation of the Dred Scott case in the 200, or my version was only 132 pages of that case that I read and picked out all the most important essential facts that were written in that case. So I uploaded into the two groups, the Moorish National Republic, the Moorish American Consulate Northeast of Mexum group on Facebook, and the Moorish American Consulate public notice page of Facebook. So you can stay with me as it relates to what I'm reading, and then after, you can always refer back to it, because it has stare decisis, res judicata cases that will be favorable for you when you're putting your cause of action suits in the proper venue, which is the district courts. Islam, because of diversity of citizenship and because you're a foreign national, you cannot put a claim in through the state. Is not advised to. They're not supposed to be able to adjudicate it. The law says that they're improper venue. Therefore, they shouldn't even be putting a cause of action against you under their criminal or civil codes within their so-called state courts, because they're outside of their jurisdiction. They know this. They can't presume it. They can't you can't give it to them, because jurisdiction has to absolutely positively be a part of the law, whereas though they can adjudicate. If it's not, it's null and void any action, all actions within quasi courts. Gonna call them that, because that's exactly what they are as it relates to you, Moors, because you're foreign nationals, alien to their jurisdiction. I'm saying a lot, but I have so much more to say. Jurisdiction is the power to hear and determine the subject matter in controversy between the parties to a suit, to adjudicate or exercise any judicial power over them. We talked about party in the first class, y'all. In order to be a party, you got to be a part of the contract. In order for there to be a contract, you have to have established some sort of contract with whatever so-called state that you domicile near, because you're a non-resident, because you are not a citizen. You're a quasi-citizen. People who identify as Negro, colored, black, African American, you are a quasi-citizen. Moors, you are absolutely not a citizen of these states. So that's the distinction between a Moor and a Moor classified and identified as a Negro, colored, black, African American. Distinction. One is a quasi-citizen, one is a non-resident. Islam? So in order for you to have jurisdiction, you have to be a party. If you're not a party, everything that has been decided within that quasi-court is notwithstanding. And there's a specific word, quorum non judice. Quorum non judice, which is its actions is nullity. You don't have to abide by them. You don't have to answer to them. They don't exist as it relates to law and as it relates to you. So the question most Moors, as well as most black individuals, are going to ask me as well, that don't stop them from messing with you. Well, in most cases it does. In some cases it doesn't. The question is, just like Dred Scott, when are you going to put your cause of action claim into a proper venue that can adjudicate that? And we're going to get to treaties a little farther down, but we're going to stay with Dred Scott for at least the first hour of this broadcast. So essential facts in this case. The first essential fact, there's 9. The Supreme Court held that the petitioner was not a citizen and could not bring the action in the court because petitioner was a slave of African descent. They are coding, they are clouding what they were really saying. They were really saying is you're not a citizen. It ain't had nothing to do with your so-called African ancestry or descendancy. They just kind of used that as an excuse. They just added that to the argument. It was the essential fact number 1's biggest issue. Dred Scott's biggest issue is that he wasn't a citizen of the state. He didn't have a contract saying that he was a citizen of the state. Islam, the African race is not, it never was recognized either by the language or purpose of the former and has been expressly excluded by every act of Congress, providing for the creation of citizens by naturalization. These laws, as has already been remarked, being restricted to free white aliens exclusively. And on the document that I uploaded to the groups is going to have footnotes of all the definitions of the words that you really need to understand what they mean. The first one was a citizen. The citizen is a member, got to be a member, of a free city or judicial society, possessing all of the rights and privileges which can be enjoyed by any person under its constitution or government, and subject to corresponding duties. That's essential, Moors. They're saying you got to have rights and privileges. Currently, as a quasi-citizen, you have a privilege, but you don't necessarily have a right. And that privilege can be taken away whenever, because they don't owe you any allegiance. And why don't they owe you any allegiance? Because you're not a citizen. Because you've never been contracted to be a citizen. Islam. The second, a slave. A slave is a person who is wholly subject to the will of another, one who has no freedom or of action, but whose persons or service are wholly under the control of another. And we need to know what a slave is. A slave is an individual who doesn't have their own identity, whose identity is solely attached to someone else's. And they owe them everything. And Asiatics don't understand how much you owe to another. And you only owe that because you deny self and identity and nationality. Islam? And a person, by the way, is a man. And a man is both feminine and masculine. It's not just male, it's male and female. I don't like using those terms. That's why I use masculine and feminine. Islam? Naturalization. I don't think I need to get to that one yet. Yes, I do. The act of adopting a foreigner. Because we already talked about in this section that you weren't a citizen. And you weren't a citizen because you never contracted to be a citizen. There was never any contractual obligations that you have or that they have to you because you were never introduced into their society as a citizen. And if you don't, and if you want to prove me wrong or prove me right, try to find out. think about it, but like, well, how would I know if I'm a citizen of the state of anything? How would you know that? What supporting documentation would you have within your persons to validate and substantiate that? Because under this so-called 13 colonies, the original colonies, they came from England, right? So if they came from England, they are England nationals, right? They're European nationals, right? Are you a European national? Did you come from over there? That hegemony is strictly for people born of that nativity. So you're not, so they're already telling you in this, you ain't a citizen of the state, you're a quasi-citizen. Because you happen to domicile or reside in our territory, which is just in your head. Because there is no landmass that is the U.S.A. or no landmass that is the so-called corporate states. I'm just going to go there. But you'll understand through other classes why that is true. Because I'm not going to belabor that point or go there. In the establishment of the several communities, now the states of the Union, and the formation of the federal government, the African was not deemed politically a person. Okay? This is all in the record, y'all. I'm getting all this from the record. I ain't add nothing. This new sovereignty, and when they talk about new sovereignty, they mean sovereignty to make their own decisions absent of England in the laws of Great Britain. That's as it relates to sovereignty. Those laws over there have no implications on how they function in the colonies of the several states. Was intended to embrace only those who were their members of the several state communities, okay? The word citizen in the Constitution does not embrace one of the Negro race. Negroes cannot become a citizen, and slaves are not made free by residence in a free state or territory, y'all. The Declaration of Independence does not include slaves as part of the people. Read it. Doesn't include it. The enslaved African race, descendants of Africans who were imported into this country, the United States as property, are not citizens of the state in the sense in which the word citizen is used in the Constitution for the United States of America. That's why I call you a quasi-citizen. You're only a citizen in make-believe. Doesn't really exist. Right? Accordingly, a Negro of the African race was regarded by them as an article of property and held and brought and sold as such in every one of the 13 colonies. And if you think that's not true today, you are sadly mistaken. You are still considered a quasi-citizen. You are still considered property because they can't classify you in any other venue because you're outside of the human family. Because families are made of nations. Nations are made of people and persons. The African Negro. The race never has been acknowledged as being or belonging to the family of nations. That amongst them, there never ever were known or recognized by the inhabitants of other countries anything partaking of the character of nationality or civil or political polity. That race has been by all the nations of Europe regarded as subjects of capture and purchase, as subjects of commercial or traffic, and that the introduction of that race into every section of this country was not as members of civil or political society, but as slaves, as property in the strictest sense of the term. So right now, through your nom de guerres, they move you, not actual, figuratively, because they're moving the straw. They're moving who you really are, which is that corporate persons, because outside of that, you don't exist. It had to be established and created for you to actually, I'm going to keep going.
Yes, please, because you got questions over here.
I got questions. All right. Naturalization. I read that to read naturalization. The act of adopting a foreigner and clothing him with the privileges of native citizen. What is a foreigner? A foreigner belonging to another nation or country, belonging or attached to another jurisdiction, made, done, or rendered in another state of or jurisdiction, subject to another jurisdiction, operating or solvable in another territory. Non-resident. So when we say non-resident, we're foreigner. When we say foreigner, only a foreigner can be naturalized because he comes from another country. Moors, black people identifying outside of their nationality. You are Moors who are foreigners, but you can't be added or naturalized into this hegemony when you're not even claiming to be foreign. Free white persons does not mean Caucasian. I'm just going, because it's a big, long definition. I'm just going to say what it doesn't mean. It does not mean Caucasian race, Aryan race, or Indo-European races, nor the mixed Indo-European, Dravidian, Semitic, or Mongolian people who inhabited Persia. So the people claiming to be white ain't white, and the people claiming to be black ain't black. I'm going to say that again. The people claiming to be white ain't white, and the people claiming to be black ain't black. Don't we got an issue here? Both operating outside of themselves. I can stop for a question if we got one or two, because, you know, what's the question? Any real questions? No real questions?
Tony Mullen Bay asks, how is nationality conferred?
What? How is nationality conferred? Okay. Where do you come from? Who gave birth to you? That's how it's conferred.
Simple. And then he said, I don't know why he said this. He asked, did you apply for citizenship?
Did who? Why would I do that? I got a nationality. Why would I apply to be a citizen of a corporation that, for every sense of the word today, don't even exist anymore because they've been terminated? Why have they been terminated, y'all? We'll get to that. Ain't getting to that right now, because that'll take me down the rabbit hole that I'm not ready to go. I want to get Dred Scott done. Political. They said that the black race didn't belong to them politically, right? Pertaining or relating to the policies or the administration of a government, a state or national. So they already telling you ain't part of this government. You ain't part of society. You ain't part of this nation. You're a quasi-citizen with privileges that can be revoked whenever we feel like it or we need something from you. A Negro. The word Negro means a black man. One descended from African race and does not commonly include a mulatto. But the laws of the direct states are not uniform in this respect, some including the description Negro, but one who has 1/8 or more African blood. What am I saying when I say that? I'm using these words on purpose because in their government, this is how they identify and classify you if you call yourself these things, right? It has no meaning outside of their hegemony, but within that. So when I'm saying Negro and yes. You got other questions? Why you, okay, you didn't. Residence. A factual place of abode. Living in a particular locality. A resident. One who has his residence in a place. A res. A thing or an object. So to claim to be a resident means you're claiming to be a thing or an object within the jurisdiction of another. Property. Chattel. Race. Race is only a classification within the European Union, y'all. Outside of that, don't even damn exist. You're an Asiatic. Race is how they identify people within their government, societal structure. Don't think about that word outside of that. Okay? It's an ethnic stock. Because within their hegemony, they had people classified based on hair color, eye color, skin color. And within that, they call you specific races. Okay? And I'm not going to belabor that point. Human beings. Human beings. I ain't going there. Y'all do the etymology on that word. Material fact and point number 2 from the Dred Scott. The Constitution has conferred on Congress the right to establish a uniform rule of naturalization, and this right is exclusive. No state of the Union, none of the several states, none of the 13 states, the 50 states, or any of the other states, since the adoption can naturalize an alien. They're using alien, y'all. They ain't say black people. They said alien. Excluded you yet again. And an alien means what? A foreigner. One born abroad. A person who owes allegiance to a foreign government. In this country is a person born out of the United States and unnaturalized under our Constitution and our laws. Are black people foreigners? Are Negro colored, black, African American, are they foreigners? Nope, because they don't belong to any government. Find it. There's no government for any of these people. So if there's nothing that substantiates you as a people, a government, how you get naturalized? You can't get naturalized. They even told you through Congress, through the naturalization process, they only can naturalize a foreigner or an alien. You're not either one. So how can you possibly be a part of a government that has excluded you in every possible way, shape, or form? And if it's not ringing in your head that you have an identity problem, ain't nothing I can do for you. They're letting you know you're enslaved because of your own willful admission. You claim to be these things that they said that you are, which took you outside of who you ought to be and who you should be claiming to be or declaring to be. The naturalization law of 1790 is confined to persons born in foreign countries under a foreign government. It confines the right of becoming citizens to aliens being free white persons. So all aliens and foreigners who go through the naturalization process of the United States are automatically free white persons in that organization. It's a status, y'all. Is that real? No law of the state can give any rights of citizenship outside of its own territory. So they give you a quasi-citizenship identification, but it doesn't succeed or it doesn't go off of their territory, which is not land. It's only in your brain. Because they have no territory as it relates to land. Because territory technically relates to land. Terra is earth. Etymologically, y'all. That's what it means. Islam? The Constitution does not put in the power of any single state to make out of one of the Negro African race a citizen of the United States. An alien is excluded because being born in a foreign country, he cannot be a member of the community until he naturalizes, right? So in order for anybody to be considered a United States citizen or a citizen of any state that they reside, they have to go through the naturalization process to become a citizen of the state and a citizen of the United States, where they have rights protected, secured, and defendable through the Constitution for the United States of America. This is why Dred Scott case got dismissed, y'all, for want of jurisdiction. They didn't have the jurisdiction because under the laws, which are the trust indenture, contract, bilateral agreements that they've subjected themselves to, bound oath themselves to, said that they can. And if they don't want to be committing treason, fraud, misprison, it's encouraged that everybody learns the law and abides by it. Because any orders, decrees, or judgments that were done outside of jurisdiction are what again? Quorum non judice. Its action is a nullity. Islam? That's number 2. So we went through 2. The first one was what? The petitioner, Dred Scott, wasn't a citizen. 1, it wasn't necessarily because he was a slave. It's because he wasn't a part of the people who drafted that social and economic and political structure. And 2, the process of naturalization through the United States to become a citizen, he was barred from. So he can't sue in a jurisdiction that he's not a part of because he's not a citizen and he wasn't naturalized as a foreigner or an alien.
Yeah, question.
Yes.
So all these people that say they're citizens and have never gone through the naturalization process, they're not really citizens.
They're quasi-citizens. You know what quasi means?
Fake, right?
Yep. Fake citizen. And they let you believe that because what? Y'all like to burn stuff down. And y'all like to act a certain way. Like, we want to be alone. We're supposed to be in this organization, in this society. So they've done it so you stop warring against them, even though you're warring against yourself by being outside of any nationality or any community, and you want to be a part of something where rightfully you're supposed to be over here repping your own nation as a Moroccan. Because that's who you are. But because you don't know that's who you are, you're staying a stateless, citizenless, quasi-citizen with no rights, only privileges that can be taken away whenever they want to. And guess what? Just because you might think you're living a lap of luxury right now, it don't belong to you. They ain't got to worry about you. That's why they ain't worried about you. You slow cooking in a pot. Mm-hmm. Slow cooking. That's all. They don't have to turn the heat up on you. That don't make you none the less dead. Just cooking slow. Material fact number 3. The United States courts can give no jurisdiction to plaintiffs or defendants in cases where it has no jurisdiction.
That's a lot.
That is so a lot. I'm going to read that again.
Yeah, I was going to say.
The United States courts, competent jurisdiction, y'all, Article 3, Constitution, can give no judgment for plaintiffs or defendants in cases where it has no jurisdiction. Meaning, it couldn't give Dred Scott a favorable reply and emancipate him because he was a plaintiff in error. Because 1, he wasn't a citizen of the state. 2, he wasn't a United States citizen because he didn't process the naturalization. He didn't go through the rules of naturalization, and because he wasn't a foreigner or an alien, he couldn't even apply. What's a state? A people permanently occupying a fixed territory bound together by common law, habits, and customs into one body politic, exercising through the medium of an organized government, independent sovereignty, and control over all persons under which it's within its boundaries. You ain't a part of no state, y'all. An alien, talked about that, it's a foreigner. The federal government. The system of government administered in a state formed by the union of confederation of several independent or quasi-independent states. Also, the composite state so performed. All right, talked about jurisdiction. I started with that. The right to proceed, the right to decide, the right to act. Got to have jurisdiction in order to do anything. So all these courts are saying, hey, we ain't got no jurisdiction to hear this case. Even though for the past 15 to 25 years, they said, oh, they were just emancipating slaves. Why was they doing that? Political gain. Had nothing to do with them caring about you, Asiatics, as it relates to you being free. They did it for their own political purposes, as it made sense at the time for them. That's why they did it. It was a privilege. They handed the privilege out. They yanked it back with Dred Scott to create precedent. So, know that for a fact. All right? And unless it appears upon the face of the record, I'm going to go back and read that again. The United States Supreme Court can give no jurisdiction for plaintiff or defendant in a case where it has no jurisdiction, no matter whether there is a plea in abatement or not, and unless it appears on the face of the record when brought here by writ of error that the circuit court has jurisdiction, the judgment must be reversed. So what they're saying is that it doesn't even matter if within the writ of error there was an error. The error can only be adjudged if the jurisdiction's there. So you want to sit here and be at the lower courts and incompetent court within the so-called counties wherever you domicile near as a non-resident. So now you want to kick it up to a higher non-jurisdictional court as opposed to just going straight to the federal court, which has competent jurisdiction, Article 3 jurisdiction, as a diversity of citizenship claim. Because you are a foreigner, and they are foreign to you, y'all don't have the same rules or the same codes or statutes or laws to adjudicate. Because if you go to a court of the so-called state, they're only going to talk about state statutes, y'all. Because that's all they can talk about. Because that's all they're authorized to talk about. They're not authorized to talk about the Constitution for the United States of America. Because they're only authorized to talk about grievances between citizens within their own state. They don't have authority to talk about anything outside of that, which is why they don't recognize the Constitution for the United States, even though they are party to it, ratified, proclaimed, in the public statutes at large. What they're ultimately saying is that, oh my goodness, we got this case that was filed in our improper venue by either an Albion or another so-called citizen, and they brought in a Moor. And the Moor declared to proclaim their nationality for the record on the record. And they did not supposedly recognize it, even though it's part of their public municipal law, codified in the public statutes at law. We're going to go to that. Going to get to that at the end. The record must show that the case is one which by the Constitution and laws of the United States, the court had jurisdiction. Consent can never give jurisdiction. So it doesn't matter if the plaintiff and defendant submits to the jurisdiction, you can't. Lawfully, a court of incompetent jurisdiction cannot proceed regardless of if the parties agree to the jurisdiction. Law says that you're wrong. Congress can exercise no power over the rights of persons or property of a citizen in a territory which is prohibited by the Constitution. Certain specified powers enumerated in the Constitution have been conferred upon it. Neither legislative, executive, or judicial departments of the government can lawfully exercise any authority beyond the limits marked in the Constitution. It's a breach of trust and a breach of duty. And it can be held for criminal actions, and part of it is fraud because they know that they know, or they ought to know, because their offices or their positions require them to know. Ignorance of the law is no excuse for violating it. Islam? You can't exercise authority you were never given. Your oaths to office and your office mission statement, your job descriptions tell you what you're supposed to be doing, so why ain't you doing that? The Constitution of the United States pledges the federal government to protect treaty rights as it is included in the supreme laws of the land, Constitution, Article 6, Clause 2. We're going to get to that a little bit later, because this is why they don't have jurisdiction over us Moors. They can't adjudicate any claims as it relates to us Moors because we're outside of that jurisdiction. Right? The state courts can only adjudicate cases between citizens of its state. Can't go outside that. So if you ain't a citizen and they didn't produce anything in the record to substantiate their claim or presumed jurisdiction or implied jurisdiction as you a citizen, they're not withstanding. Then what makes your unlawful detainment? It makes your unlawful detainment kidnapping. So Moors all over Morocco have been kidnapped. I've been kidnapped 18 months, 19 total. Why? They don't want to admit they're wrong. They don't want to admit they got to give you back everything they stole from you. They don't want to admit they are inferior to you. They call them inferior courts. The Treaty of Peace and Friendship is not with this document. I need the Treaty of Peace and Friendship. You might not be able to find it. It'd be easier if I go get it. Because I'll have it in the bag. Huh?
The bees on. I think you want to
Burn up on it.
Hey, what's this code again?
6272. The Treaty of Peace and Friendship. I ran out back to get that because I thought I had it. Right? And I'm going to segue into the treaty because it's most important. I read the Dred Scott case so y'all can get the fundamentals. The Dred Scott case gives you fundamental of every so-called black person, African American, Negro, colored issue, right? As well as why Moors won't get favorable replies in a court system that is quasi to them, which means fake to them. Treaty of Peace and Friendship. And the reasons why I'm going here is because the Constitution of the United States pledges the federal government to protect treaty rights as it is included as the supreme laws of the land. See Constitution Article 6, Clause 2. That clause says what? I'll read it real quick. I have it all in the same spot. Article 6. This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary is notwithstanding. So no state, as it relates to a foreign national, an alien, can stand if there's a treaty that supersedes it, which this Article 6, Clause 2 says is supreme law of the land. So it's part of every state's municipal law. They don't have a right or authority or jurisdiction to abrogate it in favor of their state statutes. It's against the law. It is treason. It is fraud. It is a prohibited act. Punishable. Now, they do it because we're not standing. They do it because we haven't been operating in our nobility for almost 250 years, has it been? We've been sitting here acting like quasi-citizens, and they've been having fun. Ain't no more fun going on now.
This guy told I'm about to block him.
I don't care what he got to say if it ain't got nothing to do with what we doing.
No, it don't.
They ain't got nothing to do with what we doing. Blocking. Ain't got time for Moors that ain't studied. Or so-called black people that jump on the podcast, because I invite a lot of friends. Let me tell you, I got 350 new friend requests by a whole bunch of people coming from the other African continent, because you know all continents are Africa. He was from the other African continent. They were from the other African continent. Got a whole bunch of them. I didn't accept a lot of y'all because I mean y'all call all types of nights. I ain't going there. All types of times of night, and y'all not appreciative of. I'm over here on the East Coast, and at a certain time, it's just improper. So I can't accept a lot of friend requests coming from over there on that continent because you're not mindful of the time zone difference. Islam? All right. So what does the treaty say as it relates to Moors? And what treaty I'm reading from? The Treaty of Peace and Friendship from September the 16th and October the 1st, 1836, still in force because it's codified in the treaties at law. Treaties in force document prepared from the Department of State on page 309 to 311. Shows you right there that it's still in force and still active, right? Shows you in the Department of State. But guess what document I was reading as it relates to the Supreme Court? I'm going to go there. Because y'all got to stop playing games. I ain't playing. And these are Supreme Court justices that are asserting that treaties are solemn engagements entered into between independent nations for the common advancement of their interests and interests of civilization. Chief Justice Taney said that a treaty, insofar as the courts were concerned, was a law made by the proper authority. Declared that a treaty was primarily a contract between two independent nations, a very practically the same as expressed by Brown, Justice Brown. For insofar as the court is concerned, we're talking about the Supreme. A treaty is a law to which the court at present refers by citing the statutes of the United States. The Supreme Court has accepted treaty as they are proclaimed. That is to say, whatever is designed as a treaty by the political departments in which are vested the treaty-making power will be considered by the court. A treaty under the municipal law of the United States is a compact or an agreement existing between the United States and certain other independent or semi-independent nations conforming to the constitutional requirements and proclaimed as part of the law of the United States. Supreme Court accepts as the authentic text of treaties that are found in the proclamation published with the statutes of large of the United States and does not refer to the treaty series of the State's Department. Ain't that funny? They're only telling you got to look at it in the laws, in the statutes at large for the United States for them to give it recognition. Have we done that? Yeah, because we give a certified copy from the Library of Congress, validating that the treaty we're enforcing as it relates to Moors is still binding and it's in the law codified, the public statutes at large. And let me go even a little bit deeper to tell you where. The Treaty of Peace and Friendship between the United States and the Moroccans, the Moors, is codified under 8 Stat 100 and 8 Stat 484. That's codified in the public statutes at large of the United States, volume 8. And they're telling you what pages they are on, page 100 to 104, which is the original treaty from 1787, put into perpetuity, meaning it will never, unless we, the nationals, dissolve that agreement. On page 484 to 487, which is where the what do you call it? The renewed or the renewing of and them putting it into perpetuity in 1836. So it's in the law, the Treaty of Peace and Friendship between His Imperial Majesty, the Emperor of Morocco, and the United States of America. And under Articles 20 and 21, it lets you know how claims between United States citizens or those under the protection of the United States citizens, and that would be everybody who went through naturalization. If you're a foreigner from another nation and you went through the naturalization process, you are considered property of the United States of America.
There you go.
That's all y'all who came over here. Every last one of y'all from Africa, all those other continents. And y'all got naturalized. Y'all are property of the United States of America. Through that naturalization process, read it. If you didn't read it the first time you signed it. You actually have a binding contract. You better void it. Article 20. If any of the citizens of the United States or any persons under their protection shall have any disputes with each other, the consul shall decide between the parties. And whenever the consul shall require any aid or assistance from our government to enforce his decision, it shall be immediately granted to him. So Article 20 tells you who's supposed to be adjudicating claims against United States citizens and Moors, as well as United States citizens and property of the United States citizens. It's supposed to be the Moorish American Consular Court, the Moors. So when we put our notice of, when Moors put their notice of removals to these quasi courts, and when we in effect send an acceptance and tell you to dismiss that case because you lack authority in the jurisdiction to adjudicate, it's in your best interest to do as the law requires you to do, or we got to kick it up a notch, right? Article 21 of the same treaty says, if a citizen of the United States shall kill or wound a Moor, or on the contrary, if a Moor shall kill or wound a citizen of the United States, the law of the country shall take place and equal justice shall be rendered. And the consuls assisting at trial, and if any delinquent shall make his escape, the consul should not be answerable to him in any manner whatsoever. So they're telling you the only things that you can be held criminally liable for. But again, you got to go through the proper venue and the proper jurisdiction in order for that claim to be lodged, right? That's the only criminal claim. Is there any other? So you got all these so-called 50 states trying to put you under the criminal code systems. Moors that are in POW camps. Moors that have outstanding so-called warrants. Moors that have outstanding so-called claims that they're constantly going to family court, traffic court, transportation court. I mean, they actually got drug court. I ain't never heard that. They have all these so-called quasi courts that they're forcing Moors, whether or not you're nationalized or not, to come into those venues to be adjudicated, all fraud. They know it. They didn't know it. They got public notification today. This broadcast is for all Moors, non-Moors, judiciaries, judges, administrators, all these people claiming to be within a specific jurisdiction. This is public notice for everybody to get in line with the laws of the land, the supreme laws of the land. Because to be outside of the supreme laws of the land is to be an outlaw, bandit, and a terrorist. We talked about that almost 3 years ago. You're an outlaw, bandit, and a terrorist if you're not submission. If you don't give 100 submission to the supreme law of the land. I don't have the court cases as it relates to when a so-called state statute tries to go up against a treaty. That's just like a pawn going up against an empress. Where's my empress? Islam. So I read that to say the courts don't have jurisdiction. The state courts do not have jurisdiction to adjudicate cases where a foreign national is involved. Right? No matter what the implications or the presumptions are. They know this as soon as you start saying you're a Moorish American national. They know they're outside of their jurisdiction. And their only lawful position is to dismiss for lack of jurisdiction. All these court cases are saying, oh, we don't got no jurisdiction over that. You shouldn't have to you shouldn't have to ask them to dismiss. They have no choice but to dismiss. And any action done outside of that is null and void anyway. An error in passing a judgment upon the merits in favor of either party in cases which it was not authorized to try and over which it had no jurisdiction is a grave error as any court can commit. It is prohibited by law from doing so pursuant to the Constitution. It is an act of treason. It cannot pass judgment between parties when jurisdiction has been challenged. So when you challenge jurisdiction, everything ceases to exist. Every action is nullified when you challenge jurisdiction. This is why before you put your notices of removals, Moors, you have to challenge the jurisdiction of the court. Quasi-court. It's quasi to you. It's a court to a citizen under their hegemony. But it's quasi to you. I make these distinctions because you need me to make them for you. The 25th section of the Judiciary Act to renew the case from the state court. The United States courts, writ of errors, must have jurisdiction. If not, the court cannot criticize, cannot controvert, or give an opinion upon the merits of a case from a state court. So when you're in a state court, you can't go through a higher state court. Like let's take for instance, when you go through the appellate, they say, oh, you got to go through the administrative procedures in order to get the case dismissed. If you're a foreign national and a treaty supersedes these state statutes, you're not even supposed to be in that venue. You got to kick it up to the federal courts, to the district courts, to get that case remanded back down and forced to be dismissed within that corporate structure. Right? It's the only choice they have. The federal courts, if the facts appearing on the record show that the state court had no jurisdiction, its judgment will be reversed in the appellate court for that cause and the case remanded with directives to be dismissed. That's kind of what I just said. Islam? And what's a treaty? International law, a compact between two or more independent nations with a view to the public welfare. An argument, a league, or contract between two or more nations or sovereigns. Formally signed by commissioners, properly authorized, and solemnly ratified by several sovereigns of the supreme powers of each of those states. Material fact number 4. I'm going slow, y'all. Goodness. The Act of Congress declared that slaves and involuntary servitude, except as a punishment for crimes, shall forever be prohibited in all parts of the territory. Now, when they talk about territory, again, they're talking about the United States territories, not the states. So this is letting you know that the Act of Congress, through the so-called territories that are not currently parts added into the state unions, right? So before, in the original United States of America, they had 13 colonies, y'all, and then added how many more? Was that 47 or is it 37? So they added about 37 more states, but before they were states, they were territories. So those territories were under the direct jurisdiction of the United States, federal territory, because they were not currently admitted into the states of the Union. So that's why they were not subject to those laws, and they could free slaves if they were brought into their jurisdiction under the United States under the federal district, because it was under the federal district, right? So if they talk about Louisiana in the case and then if you want to go more specifically, they talk about the Northwest Ordinance of 1787. Some people try to say that it wasn't constitutional. Some people said that it was. But we got to understand that prior to the Constitution for the United States of America, they had a whole bunch of treaties, bilateral agreements that were still in force. And the Northwest Ordinance was one of them. And if you look at the date, it was 1787. Constitution was signed at different times by different states. And when they signed on, they automatically orphaned in all those states. And it talks about that in the Constitution. Let me think about what part of the Constitution where it talks about treaties made or all the other preceding arguments. And I don't have that highlighted, but it is in the Constitution where it talks about that. And I don't want to look for it. It says it somewhere, y'all. Somebody can post where it says it, so I don't have to kind of look for it. And I'm not going to look for it. When I find it, I'll post it on in the social platforms, because all laws prior to the Constitution are also binding on the United States, because they're all, unless they have been repealed by 2/3 of the Senate and the Congress, they are still active, positive laws as it relates to the United States. Islam? Material fact number 5. The Constitution declared that all treaties made or which shall be made are the supreme laws of the land, which therefore obligates the federal government, the executive branch, to protect it and the people. So it is the federal government's responsibility to be protecting all foreign nationals as it relates to treaties. So the question is, why aren't we going to that jurisdiction to have the lower courts, the states that are being in breach and dishonor, to adjudicate and to force the lower courts to dismiss those actions? Right? Federal court, due process. We have to give due process under the Constitution for remedy to be sought or acquired. So if the lower courts of the so-called states know they're outside their jurisdiction as it relates to any Moorish American national, your responsibility as a lawyer, because you're knowledgeable in the law, is to go up to the federal district courts to get the lower courts to dismiss those actions because they were fraudulent and they didn't have the jurisdiction in order to place them. Islam?
So we should take it to federal court.
Gotta take it to federal court. That is the competent jurisdiction, as well as the Moorish American Consular Court, right? Because we supersede them. Our actions, when we give our actions and decrees, we have to be sending the Attorney General, as well as the President, as well as the Secretary of State, as well as the U.S. Marshal. These are all part of the 10 locations for submission of your nationality, so they know that you're no longer identifying as a Negro, colored, and black, and they're supposed to remove you as such within their database, let's say. So they're supposed to kick you over, and they're not doing that to a degree. Some of them are, but they're trying to act as if they're not. Material fact number 6. Territorial tribunals were not constitutional courts, but merely legislative for their citizens only. Congress cannot vest admiralty jurisdiction in courts created by territorial legislation. I'm going to leave that there. The Act of Congress, public statutes at large, established the United States District Courts and empowered them with original jurisdiction on all cases mentioned in the United States of American Constitution, Article 3, subsection 2, and codified in the United States Code under Title 28, subsection 1330 through 1333. So it tells you what's competent jurisdiction as it relates to people who belong to different so-called states, as well as people who belong to different nations, right? It says district court is the original and competent jurisdiction for that. So why are these so-called lower courts not dismissing these cases? Because they don't have, it wasn't the proper venue for those cases to even be filed. And why are these so-called attorneys of the states filing these cases within the state? Because they know they're going to get a favorable reply within those state courts, even though it's outside of law. Because if they were to file those claims in the United States District Court, guess what the United States District Court going to kick them out? Kick them all out. You don't have jurisdiction, right? Or give favorable reply to the so-called Moorish American National, because their claim supersedes any so-called corporate claim. Deed is not title to land. And the only land that can be claimed is abandoned land. So if you've claimed the land that you domicile on with a superior title, how they sitting here putting you through a so-called state court because they know darn well they're going to get a favorable reply in their state courts, because that state court can only adjudicate based on state statutes. They can't even go outside of that because they're not a court of competent jurisdiction. They're a quasi-court as it relates to foreign nationals. It has been contended that the Constitution for the United States of America, the judicial powers of the United States, extends all cases of admiralty and maritime jurisdiction. So why are they sitting here trying to claim, why are they sitting here trying to adjudicate these claims? They ain't supposed to be adjudicating these claims under admiralty maritime jurisdiction. The federal government nor any state of the union can exercise power over persons or property beyond what that instrument confers, nor lawfully deny any right which it has reserved. So this is partly why we tell Moors to reserve your rights when you're autographing documents, because you don't know what adhesions are attached to those quasi-commercial contracts. And if you're signing a so-called quasi-commercial contract under threat, duress, and coercion, you need to rescind that autograph under threat, duress, and coercion. And if you are within any of these quasi-POW camps and you're signing documents, you're signing them under threat, duress, or coercion, because if you weren't in that facility, you wouldn't sign any of those contracts. And you know darn well you wouldn't. And they know darn well you wouldn't. That's why they try to keep you in there in order to sign these contracts, which are non-binding. But if they insist on continuing to belabor the point, you got to kick it up to the federal district or the Moorish American Consular Court. Whichever one. I say do both. One superior to the other, because the reality is when the Moorish American Consular Court removes a case from the jurisdiction of the quasi-state, it is the United States District Court and the Supreme Court's responsibility under the Attorney General, the U.S. Marshal, the President, to follow through, make sure that is done. Because we gave that order as the sovereigns that they all are under. The power over persons, the Bill of Rights, 1 through 10, are not granted to Congress. They are explicitly denied and forbidden to exercise them. It is an act of treason to do otherwise. See Title 18 U.S.C. 2381. That is one of the claims, the violations that you would lodge in your federal suit to have these lower courts sanctioned or have these individuals within these lower courts brought into criminal proceedings by putting the criminal codes for which they're violating you. You are committing treason by not following the supreme laws of the land and not following the municipal code. And the municipal code, the treaty is a part of that. It supersedes any codes of the so-called state. And that's where Article 6, Clause 2 talks about. Any laws within the state that are in controversy with the Constitution for the United States of America are notwithstanding. Not to mention the so-called treaties that supersede that. The federal government could confer no power on any local government established by its authority to violate provisions of the Constitution. Nothing that is in the Constitution is the only delegated authority any one of the so-called United States of America or the states can they can't go outside of that. So if it's not mentioned in the Constitution, they can't do it. It's a violation. And the violation of the Constitution is treason. And it's fraud. Because the Constitution is everywhere and it's public knowledge and you're supposed to know. And if you sign on for a so-called office under the United States, you sign an oath. You sign an oath to support, defend, and secure that Constitution. So you can't sit here and violate at the same time. You took an oath to defend it. Islam? Now, Congress has no power whatsoever on the subject of slavery within the states because all the states were sovereign, right? We're getting to understand the limitations of the federal government as it relates to state sovereignties, right? So where Dred Scott is concerned, he was trying to go to a jurisdiction, go to a venue within a jurisdiction he was not a party to. He was completely and utterly caged in to the state statutes because the Constitution, as well as the federal government, he was outside that jurisdiction. He wasn't he wasn't included in the United States citizens. He wasn't grandfathered in through a treaty that superseded the Constitution or that was established after the Constitution. So there was no law that supported him putting his claim in through the federal government or through the district or the Supreme Court. He couldn't be heard. He was a plaintiff in error. And Congress couldn't go through the states and tell the states what to do. They were sovereign in their own capacity. And he was a quasi-citizen within the state. So he was screwed this way and he was screwed that way. But he was screwed through himself because he didn't know he was a Moorish American national and he should have been nationalized, operating within himself and utilizing the treaty and the supreme laws that supported and defended him.
To identify
nothing. When you sit here, when the first thing when you go to any tribunal, any court, the first thing you got to say is who you are. And once you say who you are, that is going to activate, one, do I have authority to hear what this person has to say? And based on who this person falls under will be the laws that I can use if they're within my jurisdiction to adjudicate. Okay? So he didn't have anything that supported him. That's why he was identified as a slave. That's why all our people were identified as slaves, and they couldn't get out of that yoke because they were outside of themselves and their nativity. There was no law supporting them. None. They only had privileges that can be revoked at any time for any so-called criminal or civil code of the so-called states. All right. The status or civil and political capacity of a person is determined in the first instance by the law of the domicile, where he is born or birthed. I ain't even going to go too far into that. A new capacity or status may be acquired by a change of domicile. Each sovereign power must determine them within their own territory. Congress has no authority to pass or bind men's rights beyond the powers conferred the Constitution. It tells them what their delegated authority is. That's what the Constitution is. What's your delegated authority? How am I to subject myself to you if, one, I don't know who you are. I don't know. Like, you'll have people come to your domicile or come to your home and sit here and say, oh, I'm here to speak to, or I'm here for this, or I'm here for that. And they ain't even tell you who they are. They had this presumption that you just supposed to automatically know because they roll up in a cruiser or because they roll up in whatever conveyance or vehicle they came in. Moors or foreigners, why aren't you sitting there saying, who are you? Who sent you here? And what's your delegated authority to be asking me a question or to being on my land? Because if you're coming on my land asking me a question, you ain't got authority to do that. That's what? Trespassing? Now that's a crime. But you got to own the land in order for that to be real, right? And you got to be in your proper person. I'm just going, Huh? I'm on 8. 67? 62, 60, 6272. Really? We're going to keep...
Listen.
I know that's right. Congress has made simple. The agent, this is material fact number 8. Material fact number 7 was Congress has no power whatsoever over the subject of slavery within the states. Absolutely none. Article 8. Congress was made simply the agent or trustee for the United States and could not, without a breach of trust and fraud appropriate, the subject of a trust to any other beneficiary or subsequent v trust than the United States or to the people of the United States upon equal grounds, legal or equitable. That Constitution tells you everything that you can and cannot do. Because if it doesn't say you can do it within it, you can't. So if it says that you have, oh goodness, let me read one. Article, the amendments to the Constitution. What you laughing at? Yeah, you know, Moore's going to ask those. Going to ask them all day, all day. Article 6, Amendment 6 says what? All crimes, prosecutions, the accused shall enjoy the right of a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of their accusation, to be confronted with the witnesses against them, to have compulsory process for obtaining witnesses in his favor, and to have assistance of counsel for his defense. Who they talking about? Because we like to use all of this stuff, y'all, as Moors. Who are they talking about in the Bill of Rights? What classification of people are they talking about in the Bill of Rights? I want to see if somebody answers that. So I'll wait.
No.
Nobody? Not a soul gonna answer that question. Who are they talking about in the Bill of Rights? What are the Bill of Rights amendments, the 1 through 10, because nothing exists after that, are they securing? Who are the people being secured? I ain't answering it for you. Damn it. I'm not doing it. Oh, go ahead. Say it louder. Say it with pride.
Not the Moors.
Right. Who they talking about? They ain't talking about the Moors because we ain't a party to this contract. This contract, we didn't establish this contract for us. Nobody in the message feed said anything.
They said the free white.
What? Go ahead. Wait a minute. No, that's
Citizens.
Citizens of what? Come on. Citizens are all over the globe and they belong to all types of organizations, government, nations. So you got to be specific. When we talk about citizens, you got to be specific. Citizens of what?
Calvin said sovereign.
Okay, keep going. Goodness
Noble
Lord.
Teresa said the U.S. citizens.
Exactly. The Bill of Rights are those secured by the so-called United States citizens and the citizens of the several states. That is what those Bill of Rights are talking about. Moors, you're only mentioned in Article 6 as it relates to the treaties. This document is not talking about you. We talk about the Constitution because it is our binding contract with them, how they're supposed to be operating commercially on our land. Do I have to say that again? This is what we hold them to. We're not held to this. So what I'm saying is what? What am I saying about Amendments 1 through 10? What am I saying? Damn, you're going to really make me say it.
I ain't going to.
You're going to really make me say it. They can't do nothing to you, Moors. They can't subject you to nothing. No searches, no seizures, no nothing. They can't forbid you to change your religion. They can't sit here and say you don't have the right to bear arms or you have the right to bear arms. They can't sit here and tell you you can or can't quarter soldiers in your home. They can't say nothing as it relates to you. They're talking about those people who are a party to this Constitution. The citizens for the United States of America. I thought that was fire. That omission. Why am I the only one getting hot? Fatima.
Because you in the sun.
I'm in the sun and it's burning me up, y'all. It's just burning me up. Again.
It's like a thin line because they're constantly asking the Moors, are you a citizen?
Yeah, that was like, are you a United States citizen? If you're saying that you're not a United States citizen, that means we can deport you through the immigration laws. What? You ain't a party to that. What? No, they can't. Fear tactics. You're not a citizen. You're a Moor. The Treaty of Peace and Friendship Articles 2021 talk about you. Talk about how they are to deal with grievances as it relates to you. Why you think they don't like using the Treaty of Peace and Friendship? Why you think they hate when we bring that up?
Because that's what the truth out.
Because it's putting the truth out, but more importantly, because all their claims are dead. They ain't got no claim when they coming up to a sovereign. They can't sit here and hold you to all their fake quasi-commercial instruments that are not even part of law. They got to take you to their venue, which is quasi to you, but they're held to. You're not held to that. You're only held to it if you think you're held to it because you ain't got the laws to support you to not be held to it. I was about to say something. I forgot what it was that fast. Oh, and let me read Article 6 that everybody likes to talk about in the Treaty of Peace and Friendship. I'm going to read it. Article 6 of the Treaty of Peace and Friendship, page 1286. Says, if a Moor shall bring a citizen of the United States or their effects to his majesty, the citizen shall immediately be set at liberty and their effects restored. And in like manner, if a Moor not subject to these dominions shall take prize of any of the citizens of America on their effects and bring them into any of the ports of his majesty, they shall be immediately released, as they will be within considered under the majesty's protection. Moors like to use that one. Moors, you're not even supposed to be being captured on your own land. There is nothing in the in the treaty that says if a Moor is captured. You're not even supposed to be captured because there's treaties telling them they can't even bring you into their jurisdiction or their venue. That's why it's not mentioned. That's why they didn't say, well, if you capture a Moor, why would a sovereign who's creating a commercial agreement in a treaty of peace and friendship as it relates to commerce got to tell you to stop taking their own people? They ain't got to do that. That's why I ain't do it in the darn treaty. Because you weren't being captured. You were capturing citizens of the United States of America. And that was a violation of the treaty. And in order for them to feel comfortable doing business here commercially, they put a Article 6 in. So if we were to capture any of their citizens and bring them to His Majesty, He would immediately release them. Am I right or am I wrong? Tell me. I like to know. I'm just going to keep going. And the last material fact, number 9, the American Revolution was not a social revolution. It did not alter the domestic condition or capacity of persons within the colonies, nor was it designed to disturb the domestic relations existing among them. It was a political revolution by which 13 independent colonies became 13 independent states. The Declaration of Independence was not to say justice chase, a declaration that the United Colonies jointly in a collective capacity were independent states, but that each of them was a sovereign and independent state. That is, that each of them had a right to govern itself by its own authority and its own laws without any control from any other power on earth. That was the purpose of the Declaration of Independence. They did not want to be subject to the laws of Great Britain and England. That was the emancipation, only as it relates to commercial. These sovereign, only the Great Britain, and independent states being united as a confederation. The people reserved to their state government and to themselves the powers they did not grant and delegate to the federal government or to the states. The 9th and 10th Amendment to the Constitution were designed to include the reserved rights of the states and the people within all the sanctions of that instrument, and to bind the authorities, state and federal, by judicial oath it prescribed to their recognition and observance. So they was making sure that they didn't do nothing that they didn't get authorized to do. And if they wanted to add any new laws or present any new bills, the so-called people of the sovereign states, the states of the Union, had to agree to it through their representatives of the states. And as in a Republican form of government, even if they want to come up with new regulations or rules or statutes of the state, every so-called state citizen had to sign on to those changes, did they not? Being a Republican form of government of the people, right? The people had to agree to those changes. Not you just want to change something that is adverse to the people, because they can go right up to the so-called government to say, they activating some stuff down there on the states that we ain't agreed to. How would they do that? The Constitution for the United States barred any states from creating statutes that were not within alignment of the federal government or the federal laws that were established. So even for the states, and we talk about the citizens of the states, we ain't talking about you Moors or you so-called black people, because you're not a party. You're not a party to any of this. Moors are only a party as it relates to the Treaty of Peace and Friendship. Black, Negro, color, African American, you ain't a party to nothing. You're property. And you know that, because everything in TV and in the news is showing you exactly what I'm telling you right now. Believe it if you want to. And what's something else I wanted to read?
Jupiter Bay wants to know, Islam, where is the Moorish American consulate?
Everywhere. Where's the United States government? Where's it at? There's a building in the District of Columbia that people call Washington, but is that the government? Where's the government for the United States of America? Ask that question. Answer that question, Jupiter. Where's the government for the United States of America? Where's it at? Who represents the government? The people, right? So who's the Moorish American consulate? The people, right? In their sovereign capacity, right? I think I answered it without actually answering it directly. And if I wasn't clear, I apologize. But I ain't going to re-say that, because I think it's self-evident. Now, the last 3 pages of the outline for the Dred Scott case, again, that was uploaded to the 2 groups, have all stare decisis cases as it relates to this Dred Scott. What cases that they refer to support their decision to dismiss this action. And there's only a couple that I want to read. Not too many. Ouch. Jackson versus Ashton. It was held that the objection to which it was open could not be weighed by the opposite party because consent of parties could not give to jurisdiction. Jurisdiction would not be presumed, must show affirmatively that the inferior court had authority under the Constitution to hear and determine the case. That's Bingham versus Cabot. The circuit court can give no jurisdiction for plaintiff or defendant in a case where it has no jurisdiction, no matter whether there is a plea of abatement or not. That's Capron versus Van Noorden. United States versus Smith. This court said that the case being brought up on a writ of error, the whole record was under the consideration of the court if the error was put. So when y'all putting y'all claims to higher courts and y'all didn't even submit anything to the record to substantiate or rebut the claim presented, what can they adjudicate? Or what can they decide? Can they decide anything in favor of you, Moors? When you're submitting your calls of actions or your rebuttals or your pleas to the court or your pleas to the jurisdiction, if you haven't put in anything or your jurisdictional challenges, if you haven't done any challenge for jurisdiction, the quo warranto, writ of averment jurisdiction discovery, if you haven't placed your nationality documentations validating that you're not a party to that jurisdiction, if you didn't put that on the record at the clerk of courts, if you didn't submit a request for the notice of removal in the acceptance of the removal, and you're going all the way up to the federal courts for them to dismiss this case, what are they going to use? If you ain't put nothing in the record. Because these are not courts of records, are they? Are they recording? They might be, but I guarantee you those recordings getting lost if you're only stating your jurisdictional challenge in the court proceedings. Because if that record don't have anything to substantiate your claim which is your adverse claim to their jurisdiction, all they got is what's in the record. So make sure you put your jurisdictional challenges on there. These are templates 19, 20, and 21 on the website. 19, 20, and 21. Templates 19, 20, and 21. It's like 30-something of them. The first one is writ of discovery. The second one is averment of jurisdiction quo warranto. And the third one is a default notice. Those are the first three documents you should be putting on any of these so-called claims. They are called your adverse claim. Because you're rebutting their claim, which is why it's adverse. That's your first three documents you put on the record, along with your nationality, a copy of your nationality name declaration, judicial proclamation, a copy of your identification cards, along with your MAC recording document that's going to let everybody know you belong to a government. That's the most important part, y'all. Because what is the purpose of nationalizing if you haven't aligned yourself with a government that is supporting and defending and protecting you as it? That's the part Moors ain't overstanding. You got a lot of Moorish organizations out there helping Moors nationalize, but then you're not recorded of any Moorish government that is doing the due diligence, putting everybody on notice, putting your directives out there. So much we're doing over here on the Northeast doesn't even make any sense. I can't talk to you about it on this broadcast. But again, there are so many cases in this document that talks about it. And the other document that I was reading was called Comment. Treaties in the Supreme Court. So it's letting you know treaties supersede all state codes, because you're not a party to those state statutes, because you're not a state citizen. You're a quasi-citizen. And if you think you want to go up against a so-called judicial officer of a state court and think that they're going to acknowledge anything that you say, you're sadly mistaken. They can't even hear it because they're not a court of law or record or court, for that matter, as it relates to you. I know you're getting crazy comments, but why care about it? Islam? So what am I going to say next? I wanted to talk about some things. I wanted to talk about Moors nationalizing through organizations and getting national identification cards. Moors, you got to make sure you're doing your due diligence so you're not getting sold up the river by your own because of their own ignorance. There are a lot of Moorish organizations out there helping to assist in fallen humanity, but they're falling you further down where you were already because of your lack of study. There was a lot of Moors talking about study, you sleepy-headed Moors. Because you don't want to study. You want everything being done for you, and you have to get engaged, Moors. You have to get knowledge. Everything that I post on my social platform, all the classes that I give, is so we can build and grow and unite together as one, because that's ultimately what our responsibility is. I am your sister. You are my sisters and brothers, and it is our responsibility to be there for each other and to be in compliance with one another. There should be no Moorish organizations aligning you to service corporation ideology. And you know that's being done based on the documentation and how it is being presented in the language and the comments that are within it. But you're supposed to be able to discern from when you're getting sold up a river. And if you can't reconcile what is being taught to you or or the knowledge you're gaining, you gotta step back and give yourself a little bit more study. And go to those organizations that want to answer their phone, that two will support you, that don't want all this fiat to help you. All lawful affidavits on our website are free. All our classes are free. We don't charge for anything but declare the processing cost for nationality, processing your documents. That's all it is, and getting it back to you. And nationality identification cards. Outside of that, there's nothing. Oh, and we'll have tags coming. I still got to find a vendor right now. I'm looking for a vendor for tags for your conveyances, and I haven't started that process because I'm so busy with getting notice of removals done and acceptances done as the Moorish American Consular Court Article 3 jurisdiction, pursuant to Article 20 and Article 20 of the Treaty of Peace and Friendship, activating that. And completing that process, as well as updating all the processes that we've been currently doing thus far, and helping Moors to understand that there's a lot of Moorish organizations that are out there and that the people are not as competent as you would like them to be. So once you nationalize with someone, make sure you send your nationality in for recording with the Moorish National Republic, federal government, Northeast and Mexican territories and dominions, which I am a supreme judiciary of, as well as Fatima Yasmin El Baisir Bey, as well as Tahir and Teptu. All this can be validated and substantiated on the website, the www.Moorish American Consulate website that I still have to update. I haven't been able to get to that yet. But every document that we talk about is on there. And if you send me an email to the Moorish American Consulate, ne@gmail.com, if you can't download it from the website, or if you need some assistance, just jot a couple of questions down in an email and I'll get back to you. But don't send me like 3, 4, 5 pages of something for me to read, because I am so busy. I cannot keep reading these long emails. Keep it sweet. Keep it to the point. And if you call, try to call between 8 and 5. Because y'all calling too late, and then y'all get us all engaged. And then Fatima's mad. And when Fatima's mad, I'm mad. Because Fatima makes me mad when she's mad. She starts screaming and my ear starts ringing.
Why are you saying that?
I love you, Fatima. You know this.
Why she say that?
So are there any closing questions? Because I don't even know how long we've been on here, but are there any closing questions? We are finished, Dred Scott, y'all. We are, see, she throws stuff at me. She's violent.
No, I'm not.
So are there any questions? We're not going to go all the way through the Treaty of Peace and Friendship, because the most important part of the Treaty of Peace and Friendship is Article 20. We're supposed to be adjudicating our own cases. With the assistance of the United States government, y'all, they're supposed to be enforcing our actions, y'all, when we give them our directives and our commands. So when we finish the notice of removals and we do the acceptances, it will be the responsibility of the Moors who have these fraudulent claims within these so-called states to send it to them certified. Send them everything certified. Why are we doing that, y'all? Because the so-called public, some post offices are obstructing.
Real bad.
They're hiding documents. They're storing them in their post offices. All right, let me talk about law as it relates to moving the mail. I'll talk about that. Morris, if you're not getting your documents, because when I send you your documents, I'm telling you what the tracking number is. It's automatically going to be tracked, because we can't rely on individuals who've been outside of the law operating for such a long time to peacefully come back to the fold of government or law. So don't ever, this is a public notice announcement, send nationality documents to 44 East Township Line Road, Havertown, Pennsylvania, care of mailing address. That is no longer the mailing address of the Moorish American Consulate. The new mailing address, mailing location for the Moorish National Republic, Federal Government, Northeast and Mexican Territories and Dominions is care of 722 East Landis Avenue, near Vineland, New Jersey. 08362. 08362.
Zero.
That's what I said. 08362. I always do that.
That's the physical.
Again, the mailing locations for nationality and identifications and any other documentation as it relates to the Moorish National Republic, Republic, Federal Government, Northeast and Mexican Territories and Dominions is, again, care of 722 East Landis Avenue, near Vineland, New Jersey, 08362. I think I said that right. The contact number is 856-982-8023.
Not everybody call at one time.
Not everybody call at one time. Have a clear, concise question, because if you don't, Chucky will come out and bite you.
Get out.
The PO box.
Get out. That's what we said. Get out.
No.
Email address, Moorish American Consulate, ne@gmail.com. Website, www.moorishamericanconsulate.org. All of these things will be simultaneously updated as time presents itself. And I love you so much. If I haven't said that the last time I was on, or the time before that, the sun is like literally beaming on my face. And I'm ready to close this broadcast. So if I will only take 3 questions, after that, we're done. It's a wrap. And Fatima going to tell me if they're good questions or if they're bad questions. If it's a bad question, we're going to keep, well, I'm going to just punk you like Chucky. I'm going to just do it. And I'm going to put your appellation out there too. So.
Jupiter Bay wants to know.
Oh, damn. I already know it's a bad question. I like, see, because you got Jupiter Bay. I love Jupiter. That's my sign. Jupiter. What's up?
Wants to know, please repeat which year treaty you are referencing.
I done put it on both the groups. I done said it matter-of-factly where it's codified in the public statutes at law. Why you keep asking me this question? I done said it 3 times. I done uploaded it, linked it to the Library of Congress, told you where it was codified, so there would be no ifs, ands, or buts about it. So when you put your claims in, you have that supported documentation to validate and substantiate your claim at the federal district, and they don't kick you out or kick your claim out because of lack of jurisdiction. The treaty gives them jurisdiction to kick it up to the federal government automatically. You being a foreign national and you having treaty protected rights as it relates to Treaty of Peace and Friendship between His Imperial Majesty, the Emperor of Morocco, and the United States of America. It's codified under 8 Stat 100, 8 Stat 484. And 8 is volume 8 of the public statutes at large for the United States of America. 100 is the page number. It's 100 through 104 for the original treaty from 1787. And then the updated treaty, which is the same treaty, just updated and put into perpetuity, is codified on page 484 of the same statute, public statutes at large, volume 8. Answer that question next. If we ain't got no more questions, I'm going because, you know, I'm hot. Pax et more, peace and love. Next class, not sure what it's going, how I'm going to draft that class, but it most likely will be on treaty. It'll be on treaty and it'll be on the Moorish American Consular Court. Peace and love. Engage.
That was a quick 2 hours. That was 2 hours?
Oh, we had 52 people on there. Okay.